All rise. The Honorable, the Chief Justice and Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by recognizance or who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated. Augustus Feleccia versus Lackawanna County, Mr. Stephen Engelmeyer, Mr. Daniel Siegel.
Go down.
Good morning. Appellees brought suit for injuries sustained while they were participating in a drill on the first day of football practice at college. They had previously signed a waiver that released the college from any and all liability. The trial court found that the waiver was enforceable and that appellees had assumed the risk of injury. The Superior Court reversed, concluding that the waiver was not enforceable and establishing a duty of care to the student athletes. Appeal was allowed to review that decision.
Good morning, Your Honor. May it please the court. My name is Stephen Engelmeyer, and I represent the appellants, Lackawanna College, and the individual defendants who are named in this action. There are two issues before the court. One, as Justice Saylor just identified, the Superior Court in a 2-0 decision found that a waiver of liability signed by two competent adults as part of their participation in the football program at our school was not effective to preclude a negligence claim, even though it used the term any and all liability. Secondly, the court below also found that there was a duty of care owed by the college to its student athletes, and the specific prohibition that was put on the college in terms of how to satisfy that duty was a requirement that it had to have qualified medical personnel present.
And perhaps, I obviously have to ask this to your opponent, but the second issue was not before the Superior Court, was it? I appreciate they decided it, but the trial court granted summary judgment on the waiver. The Superior Court had to determine, if I understand this, anything in the law, they could affirm that or they could reverse and remand. They can't go on to the next issue, which the trial court's never had an opportunity to decide.
I totally agree with that, Justice Baer, and it's one of the problems with how the court below reached their decision. You are...
All right, so you, and again, and you don't get rebuttal, and I don't know if you want to talk about that issue or not, but somebody's going to have to explain to me with great respect how that issue is even before this court. I recognize we'll have to vacate the Superior Court's opinion, but the Superior Court entered a purely advisory opinion on an issue that seems to me just not there.
Well, let me respond to that in two ways. I very much agree the Superior Court responded and it decided an issue of great import that was not briefed or presented to it. The problem obviously we have is the decision is there, it is controlling, and that is why we brought it before your honors.
Go ahead. I wanted to know if I was missing something.
I don't believe you were, and I will address that when I get to the duty of care and the Althouse analysis that the Superior Court completely failed to undertake. Let me address the issue of the waiver, if I can perhaps get rid of that fairly quickly. The Superior Court decided that that waiver of liability was not effective as to preclude a negligence claim, as to preclude a gross negligence claim, as to preclude a recklessness claim. I think based on concessions made by appellee in this matter, they, on page 20 of the brief that they filed before this court, they have conceded on an issue dispositive way that the waiver of liability does, in fact, preclude a negligence claim.
So again, and this is a very difficult case because it's just not very well litigated. I'm not personal to either of you. The second issue on our Alicata grant, and we're required to decide the issues upon which we grant and not other issues, is the exculpatory clause releasing, quote, any and all liability, end quote, signed in connection with participation in intercollegiate football enforceable as negligence. If they concede that, what's before us?
I think the only issue left, Your Honor, is whether or not that waiver applies to gross negligence. And it is our position that with regard to at least that issue, gross negligence is not a separate cause of action in Pennsylvania. And therefore, if the determination is that the waiver applies to negligence, we would argue the waiver also applies to gross negligence.
You wouldn't maintain that we're bound by that. In other words, you'd concede that that it would be within the province of this court to make a determination in the common law of torts, the waiver could not apply to gross negligence and recklessness.
Yes, Your Honor, we could. And in fact, as Your Honor knows, you've already determined the issue of recklessness. We are not disputing that. You made that decision in the Teilhard decision.
Although your dispute is whether or not the issue of recklessness is before us, given the Alicata grant. Is that right or wrong?
We did not appeal the issue of recklessness. We concede that the waiver cannot preclude pre-conduct, reckless conduct. This court has decided that. We did not challenge that.
And has anybody decided whether or not they pleaded properly recklessness? Or is that still to be determined in the trial court?
Well, Your Honor, the Superior Court determined that although recklessness was not pleaded as a separate cause of action, the allegations of the complaint were sufficient to raise that issue. We are not disputing that as part of this appeal.
Okay.
Justice Weck, if I may, with regard to the question of gross negligence, if this court were to decide that they obviously want to address that issue, as you probably know in Teilhard, you reserved on that question. In footnote 7 of Teilhard, you said we're not getting to the issue of gross negligence and whether or not a pre-conduct waiver can waive grossly negligent conduct. What this court said in Teilhard was that in order to assess that issue, there needed to be a public policy determination. You need to analyze public policy. And if you look at the Superior Court decision, what they did do in looking at the waiver is they determined, in determining its validity, although they wouldn't enforce it, but in determining the validity, they determined that the waiver did comply with public policy. That issue was not appealed by the appellees. We would argue respectfully that the issue is therefore not before the court because that determination of public policy was made by the Superior Court below and not appealed. Let me get, if I may, to the second question, which is the duty of care. I want to make two preliminary points. One is when you look at what the Superior Court did, as Justice Baer pointed out, in our view, it is clearly a new duty. No court in this Commonwealth has ever imposed a very specific delineated duty that told colleges across the Commonwealth that not only do you have a duty of care to your student athletes, but in order to satisfy that duty, certainly at least in the context of a football program, you must have qualified medical personnel at your football practices. And
now it's 25 years after the Third Circuit. 25 years after the Third Circuit predicted such a duty or a similar duty. And you're saying that the march of progress has not brought us to the point where qualified people are on the sidelines to assist student athletes who are harmed. I mean, if this stuff is done universally at high schools, why shouldn't we ask colleges to provide this sort of help?
well, Your Honor, let me, if I may, unpack that a little bit. First of all, in the Kleineck decision, which is the Third Circuit decision that predicted that this court would impose a duty of care, it's very important in our view to look at what the Kleineck court did. They were very careful in defining the duty. It was a general duty that basically said you have an obligation to timely respond to reasonably foreseeable injuries that may occur as part of an intercollegiate athletic event. Contrary to that, in this case, what the Superior Court did is they took Kleineck and went way beyond that general duty that Kleineck imposed. What this court did, and as Justice Baer pointed out, without anybody even presenting it to them, said in order to satisfy that duty of care that Kleineck predicted, and they cited to Kleineck, you must have qualified medical personnel at your practices. There is nothing in the record that indicates that high schools have qualified medical personnel at all their practices. There's no factual support for that, and that issue was certainly not presented to the Superior Court.
Was that issue, and we can obviously get the record and take a look at the statement of matters complained of on appeal between the trial court and Superior Court. Is that issue in it?
No. What was
that issue before the Superior Court at all?
Well, I would argue no, but you know, as an appellate advocate, try to tell an appellate court what may or may not be properly in front of it is got potential issues. But I can tell you, as you correctly point out, Justice Baer, what the trial court found was that the waiver was effective and that there was an assumption of the risk. That's what went up from the trial court on a summary judgment motion.
So assuming that the trial court finds that the waiver is not effective and there's no assumption of the risk, it's the appellate court, the Superior Court, Intermediate Appellate Court, says the waiver is not effective and they haven't waived their rights and they haven't assumed their risk. The remedy is to remand. All the other issues are before a trial court, not before us.
I would very much agree with that, Justice Baer. And if I may, just to support what you're suggesting, and if I may just finish and then let me get back to what you just said. The other thing I want to be clear that is not in front of this court, respectfully, from our perspective, is this is not about an assumption of a duty. This is not about whether or not the college assumed the duty to have qualified medical personnel on the sidelines, whether or not in undertaking that duty, they failed to do it properly. This is about a new duty of care, as Justice Baer is pointing out continuously, in our view, created out of whole cloth.
Wait a minute. Is the whole cloth the Lackawanna College's decision to fill 2 athletic trainer positions and require these people as part of the published job description to possess an NATA certification and then fail to ensure that the people who were on the sidelines got that certification? So how is that whole cloth when it was your client that advertised for certified trainers and said it was going to be required that these people have the certification?
Well, Your Honor, the way I would answer that is that the question of whether or not these people met the job description that was portrayed by the college, et cetera, is not the issue that we are arguing here on appeal. That's a factual dispute. There is a clear factual record that we dispute a lot of what was in there. We recognize that this is a summary judgment motion, and therefore the factual record has to be viewed most favorably to the non-moving party. But we factually contest that. And I'm back to Justice Baer's issue.
Counsel, may
Sure.
I just follow up on that thought?
Of course.
If we assume for the sake of discussion that this case went back to the trial court as a result of proceedings in this court, the appellee is free to pursue a claim based upon restatement second torts 323, which is a gratuitous assumption of a duty. Correct?
Absolutely, Your Honor.
Okay.
We are not here to say there is no potential recourse. We are here to challenge the very specific duty that the Superior Court determined without going through the very analysis that this court has required throughout several of its cases.
I just wanted to
Yes,
clarify.
ma'am.
You are not suggesting that your client could not have assumed a duty to provide a certain level of medical personnel at the walk-on football practice that took place here.
We are not making that argument,
Okay.
and I agree with what you've just said. In fact, and that's the point of the assumption of the duty is not the issue that we think is before your honors today. When you look at what the Superior Court did, what it violated, among many other things, is the Althouse type analysis that this court has required before the imposition of a new duty is in fact imposed. Justice Saylor has written extensively on this in various opinions. Siegel Prison is one, Sellers is one. This court has been very clear in looking at this question of the imposition of a new duty, and they've determined several things which we think are relevant. One is that prior to the imposition of a new duty, the better venue to determine how to balance the various factors, the competing interests that are in play before a new duty is imposed, the better place to do that is the legislature. It is the legislature that has got the ability to hold hearings, allow competing interests to have their say, to allow the executive branch to chime in on how they think the issue should be addressed. This court has also said that litigation, where advocates such as myself come up, argue the particular interest of their client in a particular case, does not necessarily allow a full airing of the issues that are associated prior to the imposition of a new duty. If a court were to undertake the type of analysis that is required, and I keep coming back to Justice Bayer's comment, that is exactly what didn't occur here. This court has said under Althouse, there is a 5-part analysis that must be undertaken. It's simple. Take a look at what the conduct is. What's the utility of the conduct? What's the risk of imposition? What's the risk of the conduct? What are the consequences if we impose a new duty on the actor who's being alleged to have acted improperly?
Respectfully, counsel, and I don't want to control your argument, but it seems to me, as I've said repeatedly, you're arguing an issue not before us, and an issue that it would be improper for us to decide, except to vacate what the Superior Court did improperly. Now, I can't tell you what the vote's going to be when we go back into that room, but before you run out of time, you may want to talk about the issue that is before us, which is the validity of the waiver.
Yes, Your Honor.
I think that issue is fairly here. The trial court threw this case out on a contract, and the Superior Court reversed.
Yes, the Superior Court reversed, at least in part, and said that it needed to go back down. And quite candidly, it's a little hard to understand exactly what the Superior Court was saying. I've read that decision multiple times. They seem to have reversed on the question of the applicability of the waiver, apparently on the issue of negligence, because they say that we weren't clear that we were waiving our own negligence. We think that is wrong. I believe plaintiff appellee has conceded on that point. The question then that remains, because we are not challenging the question of recklessness, is whether or not it applies to gross negligence. Again, I don't need to belabor the point. I think that our view is negligence, and as one court cited when we presented cases to the court, gross negligence is negligence.
Well, don't we have different jury charge? We have different jury instructions.
We do, Your Honor.
So how can you say they're the same?
Well, they're the same cause of action. They have a heightened jury instruction associated with it, but it's not a separate cause of action. So if you were to find that negligence has been waived by this waiver, then we would argue that gross negligence has also been waived.
That no matter what happens here, and this is a difficult case because it doesn't seem to me that the Superior Court opined to the issues before it, but no matter what happens here, do you concede that this case needs to be remanded to the trial court to allow the cause of action to go forward on recklessness?
Yes, we do, Your Honor, and very specifically, yes, I do want to make sure that I'm not losing the point that we do believe the Superior Court decision needs to be vacated. To respond to Justice Donahue, we are not arguing that it precludes pursuit of other causes of action like the restatement assumption of the duty. We do think that to the extent this court wants to articulate what a duty would look like outside of the assumption of duty, I would refer this court to what you did a couple weeks ago in the Dittman decision. You imposed a general duty on the University of Pittsburgh Medical Center to protect employee data that was gathered as part of employment at UPMC. You did not tell UPMC what they needed to do in order to not breach that duty. You did not tell them you need to have a cybersecurity expert on staff or you need to have a certain software. So to the extent this court articulates anything beyond a vacation of the Superior Court decision, we would ask that this should be a general duty that goes back down on the issue of recklessness for a factual determination by the trial court.
With respect to
Yes, sir.
duty, am I correct that you suggest in your papers that the scope and contours of the duty should differentiate between those athletes on the field who were recruited and those athletes on the field who weren't recruited?
Well,
how would that work?
Your Honor, the recruitment versus non-recruitment was a significant delineation in Kleineck. If you take a look at the Third Circuit decision in Kleineck, which as you pointed out is I think over 20 years old at this point, they very specifically identify the fact that the athlete had been recruited to the lacrosse program as a basis for their determination whether the college owed a duty at all. At the time, at least, there was a real question whether or not a college has a duty of care to its student athletes. And the Kleineck decision in determining that there was a duty did identify the fact that these were recruited versus non.
Do you think we should identify that as a distinction?
I think that based on the way the law has developed, Your Honor, the question of recruitment versus not is not really directly relevant to this duty of care. Once you put a student athlete out on the field, my client wants safety here. We all do. No one's trying to run an unsafe program. We would just argue there are real world competing interests. Before you tell a college the only way you can satisfy your duty of care is to have qualified medical personnel at every football practice.
What about one way to satisfy it would be to adhere to the undertakings you yourself make?
Well, that's the assumption of duty argument, and we, as I said to Justice Donahue, we recognize if they can make that factual finding, convince a fact finder that that indeed did happen, that's a separate cause of action. This is a very specific new duty of care that says to colleges and maybe high schools, to use your reference, across the Commonwealth, it's a new game in town. Before you have a football practice, I don't know if it applies baseball, basketball.
That's the next question. How far does it go?
Your Honor, that's exactly our point, is that there's as many unanswered questions by this decision as answered.
Somewhere between football and chess, somewhere.
Well, I mean, I'm serious. Is it any sport that there's contact potential?
We'll
figure it out.
Yeah,
Not even before us.
I'm answering Justice Todd's
Thank
question.
you. Thank you.
Thank you, Your Honor.
Good morning. May it please the court, Dan Siegel on behalf of the appellees. We've said from the beginning that this case before this court at this procedural level is a waiver issue. None of the issues that are in the issues granted by this court were raised or preserved below in the Superior Court. The case is about what the Superior Court held.
Well, but Mr. Siegel, you heard what I repeatedly asked your colleague. So while I agree with you that the first issue upon which we granted, whether there's a duty of care to the student athlete, is not before us, isn't it accurate that also was not before the Superior Court, their opinion was pure dicta and needs to be vacated?
Not in that way, Your Honor. What was before the Superior Court was the factual record that was supporting the basis for the Superior Court's determination that the waiver was not enforceable. That factual record included extensive documentation about the conduct of the college, which hired 2 women who they knew and were told were not licensed trainers, who failed the examinations 9 times.
Allow me to interrupt you, because the factual record does not preserve issues. You know that.
Yes.
Did the trial court make a ruling adverse to you on duty of care?
The trial court ruling was based on the waiver.
Therefore, you did not appeal anything regarding duty of care.
The issues as presented did not say duty of care. They generally stated that.
How in the world is that before the Superior Court?
I believe their analysis in terms of the duty of care is how they reached their conclusion, or as part of how they reached the conclusion, that the waiver was not enforceable as to negligence, because they looked at the various considerations that a court must determine. Because a waiver as to negligence, not gross negligence, which is not before this court and which the Lackawanna and the appellants did not ask this court to consider. The only issue was negligence. And to determine whether it was, they looked at the entire record. Part of that record includes the public policy arguments. What are the licensure requirements? What are the requirements if you have a trainer?
Allow me to interrupt you again, please, because I don't think, I understand your point.
Okay.
Don't agree with it, but understand it. Did you waive negligence? Do you concede that there, on page 20 of your brief, I believe is what was cited, you concede that that your waiver encompassed negligence as distinct from gross or recklessness?
We concede that a waiver may waive negligence, but in this case, we agree with this, that the Superior Court was correct in concluding that the waiver was not enforceable based upon the evidence before the trial court. There's a difference.
And that issue
is the difference. I'm confused. I mean, your best argument standing here before us today is that the waiver did not impact gross negligence. Are you saying that gross negligence and the impact of the waiver on it is not before us?
We're saying no, that those issues are presented to a jury, that the jury can determine whether the defendants were grossly negligent, whether they were reckless.
The legal question is whether or not a waiver is effective to waive gross negligence.
That issue is not before this court. The only issue is negligence, and this court has consistently held, and other courts have consistently held, that gross negligence is a different element, is different from negligence. There are even statutes, the involuntary manslaughter statute, there are other statutes, the Dragonetti Act. They all address a difference between negligence and gross negligence, and they are not before this court. The only issue here is the negligence issue, and that was how it was framed below. And plaintiffs never claimed that
what you want, and again, we're just trying to get our hands around this mess. Yeah. What you want, if you prevail here, we affirm the Superior, no, we don't. We vacate the Superior Court in toto, and we remand this case to the trial court to go forward on your claims of gross negligence, recklessness, and the open issue of whether there's a duty here. Is that correct?
No, we believe negligence should also be presented to the jury.
What issue?
Negligence.
Well, but that's for the trial court. They're the gatekeeper of what gets to the jury. In terms of us, what you want us, if you prevail here, is we vacate the Superior Court, we remand gross negligence, we remand recklessness, and we remand, and you get to argue this to the trial judge and maybe to the jury, the issue of whether there's a duty.
No, we believe you can affirm.
We'll figure out what we have before us. We're perfectly capable of deciding what issues are here. So, you know, we're just doing a circular thing here.
Okay.
I agree.
We know what you want, and we'll decide what you get. How's that?
Well, in fairness, though, I mean, to answer that direct question, you want an affirmance of the Superior Court.
Yeah.
Correct. We want an affirmance of the Superior Court. We do not believe that the reading that you have heard of the Superior Court decision is accurate. Superior Court did not impose a new duty upon anyone. This case is not about football. This case is not about new duties and the outhouse factors. This case is about a party that assumed a duty, Lackawanna, to have trainers, and whether it did so appropriately. That is why we cite back to Sin v. Bird and Paul's graph, because this is not new law. There is no need for this court to address or create a new duty, and Superior Court was careful. You can go through their opinion. You won't find the word present or any synonym there. They use the word available, which in Pennsylvania statutes regularly says, in terms of medical personnel, means available by direct communication, radio, phone, fax, or other electronic means. In other words, a text message, a phone call. That's the duty. That's no different from what Klein Connect said, that you needed to have people available. There is no need for this court to create a new duty. Superior Court did not do so, and it's subsumed within existing case law, Section 323 of the restatement, in which if a party assumes a duty, as the college did
We
here.
understand, and therefore the answer to the question is, as Justice Weck said, you'd like this affirmed, that's all.
Yes,
Can't we
Yes.
agree on that?
I would agree, yes. Thank you.
It's not about football. We wouldn't agree on it if we didn't know it was about football.
Yes.
It's kind of about football.
Thank
It
you.
could happen in
Thanks
any
to both of
sport.
you.
Thank you.